Hey everyone, thanks for joining me. I'm going to wait a couple minutes here, or a couple seconds at least, to get some people to see if any people are coming in live. Oh, I already had people in the chat room. Started a couple minutes late, sorry about that. I just wanted to talk to my guests to give them an idea of what's coming up. And they're backstage waiting, but first I just want to say thanks to everybody for joining in. As you probably noticed over the last couple days, I've been rebranding my channel and my Facebook group. And so the reason for that, and you're probably wondering why, the reason for that is that using the basically a lawyer tag was when I was doing the really hardcore legal breakdowns of the case. And I can't do that anymore because of this neurological issue I'm having. My memory, I'm struggling with that. Even remembering the legal stuff when your memory is good is difficult. And I'm really struggling with memory. So anybody that watched my videos from like 9 months ago when this started knows that I was really struggling with things that I knew and couldn't come up with the words and the concepts. But I took a break for a while, and unfortunately the problem hasn't gotten better, but I still want to be involved. I still care about this cause, and I still have a voice, even though everything else isn't going so great right now. I still have a voice. And if you watch Mammothon at all, you know that I had a few people on. One was wrongfully convicted and still incarcerated, and then I had 2 other exonerees on, and I really enjoyed talking to them. I really enjoyed hearing their stories. I guess enjoy almost seems like the wrong word, but I did like hearing from them and hearing about their perspectives and what they're now doing to help raise awareness for this cause. And I decided that I wanted to keep focusing on that. So I rebranded the group. It's now called the Scales of Injustice, and it is going to be covering anything having to do with wrongful convictions. You know, I'm going to be interviewing other exonerees, hopefully more attorneys involved in these cases. Anybody that wants to come on and shine a spotlight on a certain case, I will have them on. I think it's really important that education is very important in this case, and the more we learn, the more we know about what we can do to stop this from happening in the future. So I just wanted to explain that to everybody right away. Now today, my 2 guests, I have Ricky Kidd with me, and he was on with me during Mammothon, and he is an exoneree. He was wrongfully convicted for 23 years, and he's been out for about 7, maybe close to 8 months now. And then my other guest is Lindsay Runnels, and she is a defense attorney and a civil rights advocate, and she is currently one of Lamar Johnson's current attorneys. So we are talking about the Lamar Johnson case today. And so it's really great that Lindsay wants to be here with us so she can really help us understand what is going on with this case. And I'm not going to say too much more about it because we're going to cover that, but I have read a lot of legal briefs and I've read a lot of legal issues in these wrongfully convicted cases. And this is honestly one of the strangest, just because the state is almost fighting against itself at this point about whether Lamar should get a new trial or not. And it's infuriating, it's fascinating. But I'm really going to let Lindsay explain more of that. So I am going to bring them both on. I already introduced you guys a little bit, but I'm going to have you go through and tell everybody a little bit more about yourselves and your connection with Lamar. Ricky, you can start.
Oh, absolutely. Hey, Tracy.
Oh my God, my dog. Sorry.
And everybody in the listening audience out there. My name is Ricky Kidd. And as Tracy said, I was recently exonerated August 15, 2019, about 8 months ago, after spending 23 years in hell. And I had the opportunity to meet Lamar Johnson in that hell. Unfortunately, he's still in that hell, and we're trying so hard and desperately to get him out. But Lamar and I became real close over the years. We were cellmates for a period of space and time, and that's how I know Lamar Johnson. So.
And I'm Lindsay Runnels. Hi, everybody. I'm one of Lamar's lawyers, and so that's how I know him. I've known him actually since I was a law student. Strangely enough, I worked on the case as a law student very briefly, and then got re-engaged with the case in late 2013 or early 2014, and have been among his counsel since that time.
And you were also a law student on Ricky's case, correct?
That's true. My very first legal visit in custody ever was to see Mr. Ricky Kidd. And I was terrified, not of Ricky, of course, but of him finding out very quickly that I didn't know what I was doing. And him being totally insulted that a law student had been sent to visit with him.
So Ricky was your first exoneree then?
I was not on the legal team.
I bet you worked on the case.
Yes, I worked on it as a law student, and I was closely involved with the group that was doing it. And so I was available to them for moral and emotional support, but that legal victory, it is not one that I can claim at all.
But she can, and I have to jump in if I can real quick. She definitely can share it. I feel that way. She's right technically, but I feel like she definitely shares that anybody who puts their hand to the plow or put their hands involved in a case like mine or others who play a supporting role, who actually does some type of work in some type of way, contributed towards the overall victory, even if it was just keeping me uplifted and encouraged. So I've always seen Lindsay as one of my team members, and really I still do. So
I wouldn't think it's any different than any of the legal assistants, the clerks, anybody that's helping out with this case. I think it's a victory for everybody involved, the supporters, families involved. I mean, it really takes an army to battle this kind of injustice.
It's a characteristic of Ricky's case, of course. The number of people that had a hand in Ricky's exoneration is infinitely long. Same with Lamar Johnson, and all of these cases require, sadly, an army of not just lawyers but supporters in the community, and from all the way from legal team into the community. These things do not happen in a vacuum.
Now, Lindsay, did you always know you wanted to go into this type of work, or did you just sort of fall into it with whoever you were working with when you were a student?
I definitely did not know.
Okay.
to do this. I went to law school as a very brief stop off from a previous life of working after undergrad, thinking I would go back to that work, which was, legislative and political. And I was in a clinic with Sean O'Brien, who is a, very well-known innocence and capital lawyer. And I was in one of his clinics and very quickly realized that this is what I was going to do. So the change happened quickly and in law school, but I did not go to law school to do this. So
sometimes that's the best way for things to happen. You just go with the flow.
Right.
So, okay. So getting to Lamar's case, Lindsay, I'm going to start with you, and whatever you can, I'd like you to tell us about the crime itself, how Lamar got involved, and ultimately what led to his arrest and conviction.
Okay. The crime is, ultimately, quite simple factually, but like so many of these cases, it gets very complex. But the crime happened on October 30th of 1994, right around 9 p.m. Marcus Boyd, the victim in this case, and Greg Elking were sitting on the stoop of Marcus Boyd's home. Greg Elking was a customer of Marcus's crack cocaine business. Marcus had a job and a family, but like many folks, living in the part of town that Marcus lived in, he also sold a little bit of crack cocaine to get by. And Greg was one of his customers, and Greg had come by to purchase crack cocaine. And they were friendly. They also worked together and shared rides. And so they were also arranging for their ride to work on Monday. And two fully masked Black men ran up from what they call the gangway in St. Louis, the space between two apartment buildings, came up around the porch and had a brief struggle with Marcus Boyd, shot him, and then ran and left the way that they came. They didn't steal anything. They didn't take anything. They didn't harm Greg Elking at all. And it was over almost as fast as it began. So that's the factual, basis of the crime. The motive at trial, what they tried to allege was that Lamar Johnson and Marcus Boyd, who had been best friends and friends for a long time, had a so-called drug beef with each other where they had been in business together, but things had gone south. and that this was done because of this feud, so-called feud between the two of them. Subsequent investigation unveiled that all of that motive evidence was manufactured, sadly. But Lamar Johnson was named as the only suspect on the scene of that homicide before Greg Elking, the only witness to the crime, had even been located. Elking hadn't been located for 3 days later, but yet Lamar Johnson was named as the suspect in that crime at the scene.
So how did he become a suspect? Who pointed the finger at him?
This is a great question and one of the mysteries in the case. And someday we'll be able to ask that question of the law enforcement officers in the case. But right now, I don't know the answer to that question is the honest answer. And I think there's only one or two people that may know the answer to that question.
So once Lamar became a suspect, was he arrested? I mean, obviously he was probably brought in for questioning. What led to him being arrested?
So there were 3 days that they were trying to locate Greg Elking. They didn't even know his last name. Leslie Williams, which was Marcus Boyd's girlfriend and the mother of his young child, was in the upstairs apartment at the time. She heard the gunshots. She ran down the stairs to the exterior porch and saw the men that were fully masked running away, unable at the time. She said at the scene and throughout trial that she was unable to identify anyone and did not recognize anyone. So she wouldn't be considered an eyewitness even at trial. That testimony, though, I mean, she testified that she thought that Lamar and Marcus had drifted apart, and they had, because they both had women in their lives that wanted them to be doing something different, and so there certainly was tension between them, but they had spoken up until the time of the crime, but certainly nothing to the extent that the government alleged, the state alleged, which was that Lamar went to kill him with the intention of killing him, and over some drug beef that did not exist. So once they finally found Greg Elking, they brought Mr. Elking first to a diner and showed him 5 photographs, what we would call lid photographs. And Lamar Johnson was among that photo array. How and why Lamar would have been in that array is a question that remains to be answered, because at that point there had been no testimony about, from Mr. Elking, the only person with any ability to see, to even describe, a suspect. So he doesn't make an identification by his testimony. He says, I was telling them I couldn't recognize anyone because, remember, these are fully masked, ski masked, black men at night. So the thought that anyone could really make an identification if we knew nothing else about the case would be a pretty problematic factual scenario, especially in 2020 with what we know about eyewitness misidentification being the number one cause of wrongful.
Right.
That aside.
Okay, go ahead. Sorry.
He's saying I can't make an identification, but the police narrative suggests that he could have, but he was scared to do so. And at that point, Mr. Elking testifies that he was offered a number of incentives to become a witness in the case. A few hours later, they locate Lamar and Phil Campbell, a co-defendant, bring them down to the station for what we would call, the live lineup, what you see in the movies and things like that, where they really have 5 folks or 4 folks in this case standing and someone behind a window trying to identify them. Mr. Elking was presented with the lineup, including Lamar Johnson, makes no identification the first time, says he doesn't recognize anyone. Second viewing, still doesn't see anyone. On the third showing of Mr. Johnson's lineup, he chooses a filler from the city jail in a position, that wasn't Lamar Johnson. He identifies a man named Donald Shaw. Today, he would tell you because he looked most like, in all of the research that we know about wrongful convictions and eyewitness identifications, that's exactly what witnesses do. They choose similar And so the identification was problematic from jump in this case. They get into the elevator, and the story goes that Mr. Elking told the lead detective in the case, I really could identify the person, but I was scared. And this person was in position 3, which is where Lamar Johnson was. Mr. Elking's been interviewed a number of times, and on his own wrote to a reverend, a very prominent reverend in St. Louis, Reverend Rice, in 2003 saying, I did something, I identified someone falsely, I lied at trial, can you help me make this right? Before any contact with Lamar Johnson's defense team. And so Mr. Elking testifies that he asked the detective, if you tell me the numbers, I'll tell you if you're right. And then, it goes from bad to worse, and an identification is made at trial. And jurors, and understandably so, find evidence like that incredibly persuasive, where there's someone on the stand and says, that's the one, that's him, I saw it, I was there. Jury after jury gives great weight to that evidence, even though we know it's compromised in the best of circumstances.
Now, didn't law enforcement, or even in the trial, I assume they made it known that these people were wearing ski masks, correct?
Yes.
So how can this identification even be reliable anyway when all you could see are the eyes?
It's such a simple and good question.
I know logic is lost in this case.
But in courtroom after courtroom, we see, really tragic and appalling instances of evidence presented like this. I mean, we see it in, bite mark evidence and, what we call trace fiber evidence, where someone will say, well, that's the bite mark to the exclusion of all other bite marks. And we know now that that's just junk evidence, right? But juries find evidence like that presented with authority quite persuasive. And now, nearly 25 years later, we know a lot more about eyewitness identification, certainly, but this case isn't a misidentification case. It's a misconduct and a manufactured identification case. Greg Elking never could make an identification. It wasn't that he just got it wrong, for the reasons we know witnesses get them wrong. It was that he never could ID, and he made an ID for a number of reasons. Some of them, understandable. He cared about Marcus Boyd. He wanted justice for his friend. This was his friend. He believed the police, as so many of us should and can often do. He believed that they had the right person for this. He wasn't trying to wrongfully convict Lamar Johnson. He was trying to be helpful. He was trying to do justice for his family, the family of Marcus Boyd and his friend. And let's be honest, he needed that money. $4,000 is a lot of money today. It was a lot of money in 1995 as well.
Right. Now, in Missouri, I'm not sure, I'm not real familiar with their court system or their laws actually, but do they have a grand jury system, or do they have a preliminary hearing to establish whether there's enough evidence to move forward?
So it's a combination, right? We indict in a variety of ways. So you can indict by information, which is what happened in this case. And prelim also happens by request. They're often waived, as they were in this case. So he was indicted by information. A grand jury didn't indict in this case. And then prelim was waived.
So what exactly, was there anything besides this eyewitness identification that was presented that led to this case moving forward?
So there is also, as often is the case in a wrongful conviction, a collection of errors, So we have a incentivized informant, and those are the legal ways that we describe them. Most folks know them as the jailhouse snitch.
Right.
There was a man named William Mock in the city holding area, which I don't know how many of your viewers are familiar with jail at all, but holding areas are a different part of the jail. They are a place for processing, It's a lot of moving in and out of those areas. People bond out quickly or OR quickly. If they're going to stay for a pretrial setting, they will move to another part of the jail. But this portion of the jail has, 10, 11 cells and a lot of people in each of them. They are, tanks of folks inside of them. They're loud, they're crowded. And that is where this supposed Mr. Mock overhears who he says he believes is Lamar Johnson yelling to his eventual co-defendant, Phil Campbell, about the homicide. They were never celled together. They were never even in the same holding cell. And what we learn about William Mock down the road is a lengthy, over 200-page criminal history, as well as history of incentivized informing for the state under bizarrely similar circumstances. 2 years prior to this, him being in the perfect place at the perfect time to hear someone confess to a homicide in a jail, which is out there. 2 years prior, he had been in a holding area and also heard a confession to a murder.
People just want to open up to him, I guess. Yeah.
He's like a unicorn. But none of that was known to the jury. They didn't know of his luck back in 1992, which of course he traded, benefit for himself for that, as is the name of the professional snitch game. I mean, it is a professional business of snitching. So none of that was known, as well as a number of other things about Mr. Mock that.
Excuse me a second, but I might be getting ahead of myself, but was Mock given any consideration specifically for testimony in this case?
Yes.
And if so, was he asked that at trial, and did he disclose that?
So yes, he was given benefits to himself. Portion of it was disclosed. So what was disclosed to the jury was that the prosecution had agreed to write a letter on his behalf to Board of Probation and Parole for him, which they did do, and that letter was disclosed to the jury. What the jury did not know was that there was a number of undisclosed benefits that he also got, not to mention a series of letters between the prosecutor and Mr. Mock, where there is details of this, what he wants, what he's asking for, his demands. This is all happening pre-trial, where he's writing to the prosecutor, and then he's calling Lamar a two-bit N-word, which is evidence of witness bias and animus, also must be disclosed, because a jury should be able to listen to the cross-examination about that, because if a witness is biased, right, that's perfect cross-examination material, and then the jury gets to decide with all of the evidence before them, can I believe this person if I know all of these other things? So the jury didn't know anything about that, as well as the payments to Elking. I mean, they didn't know.
Right. Well, of course, yeah, definitely wouldn't know about that. What about, was there any actual physical evidence tying Lamar to this at all?
No, there was no physical evidence. Lamar's alibi, a good alibi. The problem with alibis is, where were you last night, Tracy?
Right.
9 p.m. or 2 weeks ago at 9 p.m., 10 p.m. Who were you with, and who your alibi? It's your family, most likely, for most of us.
Well, especially right now. Yeah, definitely.
So family witnesses come with them, the bias that we all talk about, right? So they can't ever stand alone. We have to corroborate them if they are to be persuasive to a jury. That did not happen in this case. But Lamar also had two other friends that were there.
Right.
They were not called to testify. So the only person called to testify about his alibi was his girlfriend at the time, the mother of his child. So, it's pretty easy to attack that when it's just her standing alone. Well, you'd lie for him, right? Well, I mean, maybe, but I'm not,
Right.
Those type of things, you have to bolster them with other evidence. You have to corroborate them, or the jury is left with, well, I'm just not sure. And most of the time, they're not believed if they stand alone. This case, there was no need for them to stand alone. There were two other people there. In addition, there would have been phone records and pager records because Lamar is paged by his Pam Williams, his former girlfriend, saying, Marcus has been shot. You know, call. And he calls immediately. And they three-way in Leslie Williams, who was at the scene, and they're all talking to each other. It is an impossibility that Lamar Johnson could have been in two places at the same time.
Right.
And all of those records certainly would have been available in 1994.
Oh, absolutely. Yeah. So what other than this alibi, what else did Lamar's defense attorneys do to put on a defense for him?
So they attempted to challenge William Mock, of course, because, you know, it was obvious that he had a serious criminal history, but only the tip of the iceberg had been disclosed at that time. The same with Greg Elking, attempting to challenge, like, this is an impossibility that you could identify anything, right? But the defense was pretty hamstrung. Really critical impeachment and exculpatory evidence was not disclosed in this case. So there certainly could have been more done on the investigation side, but this case, in my view, happened almost, not entirely, but mostly because of the government's misconduct.
So how long did it take for them to render a verdict?
I think it was about 3 hours.
Oh, wow. That's it. Huh.
It was short.
Now, one thing I want to mention is that he did have a co-defendant. Were they tried together or separate? No, they were tried separately, correct? Because
separately.
Lamar was tried first.
Yes,
correct?
Lamar was tried first. And after the trial, Greg Elking stopped cooperating. After Lamar's trial, Greg Elking stopped cooperating for a couple of reasons. First, some of the payments had stopped. And secondly, he had a real bad feeling about seeing Lamar for the first time in the courtroom. He was thinking, I'm not sure, and feeling guilty about it. So he stopped responding to inquiry from the prosecutor's office. When Greg Elking falls away from the case, there is nothing really left. I mean, you couldn't get an arrest warrant without Greg Elking. So it's unlikely that they could try the case. They offered Mr. Campbell a deal. He was sentenced to 7 years for this homicide, and he served about 5.
And jumping ahead, he actually is one of the people that is guilty of this crime.
Yes, he is.
Confessed later on.
Yes, and he's been saying that since they were in the city jail together. A number of letters between he and Lamar where he's apologizing to Lamar that Lamar is even in this case. So
well, he pled guilty to, I think, voluntary manslaughter, correct? So he pled guilty, but not to first degree.
Right, absolutely. And a 7-year sentence, you know, that wouldn't be what you would get for a first degree. But I mean, I think I don't know why the government offered him what they offered him. My guess is that they didn't have any evidence left. Without Greg Elking, they had no way to prove the case.
Did Campbell have to testify at all against Lamar? No. Okay. All right, so let's move on. I'll give you a break for a second, and we will move to Ricky. Now that Lamar has been convicted
wrongfully.
What? Go ahead. You can start. You can talk about that, about your relationship with Lamar.
No, I was just helping you. You said now that Lamar has been convicted. I said wrongfully.
Oh, wrongfully, yes.
Go ahead.
But no, now that he had been convicted, even though we know it was wrongfully so. Once he was incarcerated in 1995. Is that when he was convicted? 1995. When did you meet him?
I met Lamar in 1997. I was charged in May 22nd, 1996. I was convicted March 24th, 1997. I entered the Missouri Department of Corrections just a few short months later in June of 97. And so I met Lamar maybe 30, 60 days into my horrible nightmare.
Where were you guys at? Were you at Charleston?
Yeah. No, we was at Potosi Correctional Center. Yeah. So Lamar and I meet at Potosi Correctional Center. And there's a reason why Lamar and I consider ourselves best friends or real close friends for many of reasons. One of them, or a few of them, were along the lines of the fact that we both like to read. We was writers. We're really quiet, really laid back men. I'm from Kansas City. Lamar's from St. Louis. But we had so much in common, more than we realized at the time. And somebody had recommended to Lamar, because he was also the type that didn't want to blend in real quick with the prison environment. And we later talked about why both of us was that way. So although Lamar and I was innocent of our crime, we were, I guess you could suppose, at least I can speak for myself, guilty of poor choices, friends, lifestyle choices. And so when I came to prison, just as Lamar, we don't want to have nothing to do with, and it's filled with a bunch of shady people who still not done with their criminal activity or their criminal thinking. It was a hard pill to swallow to find myself in prison for a crime that I did not commit. I know it was a hard pill to swallow for Lamar as well, because we talked about it. And so what we would try to do, unbeknownst to each other at the time, is try to find a different path, a different set of friends with common goals more central to our core self. Because Lamar is a great individual, human being of an individual. So people had suggested that, Lamar, you might want to talk to Ricky Kidd. He writes, he reads, y'all seem more similar in style. Lamar pulls up on me at a table. He introduces himself. We have a seat. We began talking, and instantly our commonalities, our vibe, our energy, we connected. Now, we didn't connect as it relates to our innocence because we did not know that at the time. But we just talked about the different type of books we like to read. He was more so of a literary writer. I'm more of a creative writer, but we was very passionate about our writing. And then we like to work out as well. So that was another commonality. And one day while we was working out, Lamar was headed to the library, and he said, man, I'm gonna have to cut out on you. I'm gonna go to the library. And I said, that sounds good. What are you working on? And then he kind of stumbles a little bit to share, because when you talk about your innocence in prison, people just tend not to believe you. And I recall Lamar saying to me, well, you might not believe me, but, and then he's chuckling and he's pausing. I'm saying, what's up? Spit it out, my man. He said, man, I know people hear this all the time, but I'm actually innocent. And so I just looked at him and started smiling. And I said, well, I know you might hear this all the time, but I'm actually innocent. So here, and then we both just fell out laughing. Here it is. We both was afraid to talk about our innocence, because in that community, that prison environment, everybody says it, especially among inmates, even in a free society, nobody really believes it. But it was funny. It was funny and refreshing at the same time. It was refreshing because, as sad as that may sound, because you think you're alone. Before I was incarcerated wrongfully, I did not even think innocent people go to prison. I had no frame of reference. I had no frame of reference, no paradigm, nothing to compare that to. And then to get inside prison, I'm thinking I'm the only one, or at least among a small few. I'll never run into another innocent person. So to run into Lamar, and then we talk about us both being innocent, that made the connection even stronger for us. After that point, we found ourselves always still reading, writing, working out in the law library, studying our cases and shepherdizing case law. And one of the things that we also did is we began a strong, fierce letter writing campaign to churches, organizations, lawyers, anybody that would hear our cry written on paper that we was innocent and we needed help. And sometimes when we come together, I'll ask him, did you get a response? And he may ask me, did you get a response? And I may say, yeah, I got a response, but they only gave me a resource sheet, a sheet that says contact these people, and then those people don't even respond. So out of about 100 letters, you might get one or two response saying, sorry, there's nothing that we can do. The other 98 don't even bother. But that's how Lamar and I met. We worked hard and fiercely on our case. My case had caught some traction with the Midwest Innocence Project at the time. So things began to happen for me. Some filings started going inside the courts while Lamar was still in the waiting pile at the Midwest Innocence Project, because it's 600-700 cases or applications, and he's just in the pile somewhere. So he was still waiting, always hoping and wishing, and then working on his case to the best of his ability himself. I was always fascinated by Lamar's focus, drive, and ability to really help flush out his own facts. He was very, very thorough with spotting and dotting, what do we call spots and dots, checking the spots and dots, and being able to show, wait a minute, this isn't right. Wait a minute. He learned how to send stuff off to the Missouri Highway State Patrol, the Sunshine Law, things he knew before I knew how to do. He actually taught me. But he was always fierce, just as I was, and he was always adamant, just as I was. And I will tell you, Tracy, and to your listening audience, there's a lot of people who say they're innocent. In 23 years of hearing that, there may be 5 people who I can stake my reputation or my life or the breath I breathe on the fact that I believe that they're innocent. Lamar is definitely at the top of that list, not just because we're considered best friends or close friends, but because his facts, as it has come out, it was always strong. And we wasn't even supposed to really discuss our cases with each other. That's a no-no. But we felt this vibe and this energy and this trust, and we would share our cases and case information. So I knew early on that this guy was the real deal. He was telling the truth.
Now Travis, we're going to answer your question later on. That's coming up. You're getting ahead of us. I'm going to put up another question here right now while you're talking about this from Eric Jose. It says, question for Ricky. Were you able to review your whole case file in prison, or did you have to review it in segments?
No, I had access to my entire case file, and I was able to dig in just like Lamar and really start flushing out. We are the first investigators, so to speak, or the first lawyers, so to speak, after the conviction, and you are not receiving a public defender anymore. And you really got to get in there yourself and try to, because so many people say I'm innocent. So don't show up at my office, or don't let this letter show up on my desk, or don't call my phone saying you're innocent unless you really got something tantalizing to at least get started and pointing to. And that's our job. That's our job as innocent individuals, to kind of find that, because the courts is overwhelmed. The lawyers, the public defenders overwhelmed, and even lawyers, pro bono lawyers, they're overwhelmed in innocent projects. They're overwhelmed as well. And so we are the first responders, so to speak, when it comes to actual innocence, individuals actually innocent. And we need access to our entire files. Fortunately for me, and I believe so the same for Lamar, we had access to our files.
Yeah, I believe he asked that question because in the Avery case, Steve cannot have his entire case file because it would take up, it's bigger than his entire prison cell. Yeah. So he's never been allowed to have his entire case file at his disposal. And he had to do a pro se petition, which we will talk about with Lamar too, because Lamar did several pro se petitions and how difficult that is to begin with. You don't have the resources, you don't have access to investigators, and you just don't have the resources to be able to really, truly give yourself, your best effort when it's coming to an appeal.
I'd add what Ricky had just said. He's talking about, the role and the responsibilities of the innocent person, which I agree with Ricky that they are often the best advocate for themselves. And I think that is important. But to put any of the onus of finding new evidence on someone that is behind bars without any funding, without any resources, is, in my view, not acceptable and intolerable, and we just are never going to get there. They're never going to be able to do the amount of work that is required in these cases. And so counsel must exist for these folks. I mean, the pro se winning petition is not real. It's one of those things. It may look like on paper that if everything somebody says is true can be proved, they might have something, but that's not our standard. Our standard isn't maybe if we give all the benefits of the doubt. You know, it's fact pleading. It's not, you know, we think this would be true if we ever had the opportunity to look at records that we don't even know exist, you know?
Right.
So I'll just add that.
Yeah, that's a good point. And if I could spin behind Lindsay with highlighting her point, we definitely can do it, because when you're at zero, when you're at zero and the magic number is 10, but you move from 0 to 3 or 4, you think you've done something. As an innocent individual, you think that I've snuffed out enough, I've written, and she's so perfectly correct. Because I remember even with Lamar and I, we would write these. We both had typewriters. That was another thing. And everybody couldn't, of course, afford typewriters. But that was one of the things that we sacrificed for. It was our computer. And we would type these. We think this is good stuff. We think because we feel like we've moved, and we have moved. But the standard and the bar is so high. What Lindsay is talking about, when real lawyers come along, you think that you can just hand off your case. I remember helping Lamar put his these motions and these petitions together, and I think Lindsay had just come on board, and we passing this stuff off, thinking all you need to do is just look at this and file it. Just look. But we only went from 0 to 4, so naive in understanding that it's a far greater threshold, and that you definitely need lawyers. And man, they had to almost scrap everything that we would present. Same with me in my case and my lawyer, and start over. Great job. You kind of gave us some good places to start, but we're not going to be able to take this motion and file it, meaning it's going to be some years still before we dig this, unravel good start. But we need to unravel, because lawyers also can't believe what we just say. Good lawyers won't do that. They won't take these motions and here's what I found. Once again, good. You can point me in the right directions, but we're going to have to snuff this out for ourselves, unpack, repack this together. It's going to take a while. It does take a while. And even when you move from a 4, which we always thought was a 10, you still only find your way at an 8 or a 9 because it's just that difficult to get these appeals overturned, or to get these cases overturned.
And statistically, I mean, even though you said you felt like you were probably the only person that thought that was innocent in prison, there are actually about, I think I got this from you, about 115,000 innocent people sitting in prison right now.
Yes.
Right? Is that the correct number?
Yes, that would be correct from studies and things that I've looked at. Dr. Samuel Gross over at the University of Michigan, the National Registry for Exonerations speak about these numbers. There's many studies that suggest, Tracy, that 2 to 5% of the U.S. prison population is a result of a wrongful conviction. And there's about 2.4 million individuals inside our U.S. prison system. And so when you do the math, if we just, for your audience, take 10% of 2.3, and that's 230,000, take 5% of that, and you're talking about 115,000. And so that's where that number comes from. It's not a made up number. And even if we go ultra conservative and drop that down to 2.5%, you're still talking about almost 60,000 individuals wrongfully convicted in the U.S. Even if you go ultra conservative, which prosecutor associations have admitted that it's about 1%. They say we get it right 99% of the time, but only about 1% is the result of a wrongful conviction. You're still talking a good 30 or 40,000 individuals across the country. That's a still high number. Lamar, Steve, and many other great individuals represents that awful number.
So we lost Lindsay for a minute. Let me add her back. There she is.
Sorry.
That's okay.
So.
Oh, yeah. And if you do, I should mention, if you do need to get up and take care of something, you can always just click your microphone and your video to shut them off temporarily, and then just come right back too. You don't have to worry if you have to get up and do something. So now this is a little bit off topic. Well, it's not off topic, but this is getting away from Lamar specifically for a second. But while we're on the topic of statistics, How many exonerations, do you know the number, have come from people that were on death row? Around 130? Is that about right?
Yes, I mean, I don't know the exact,
Right.
but it's about, 130.
So, and we know from, I don't care what they say if it's official or not. We know there have been a lot of people that have been executed that were innocent already. And so, so I just want to bring that up while we're talking about statistics about this isn't just about people losing their liberty. People are losing their lives over these. I don't even like calling them mistakes. Some wrongful convictions are mistakes, but there's a lot of malice involved in these. There's a lot of malicious prosecution, and that's really where this needs to stop. Anyway, okay, that was me getting on my soapbox for a minute.
Some of them are legit just mistakes. There are cases where we just see things, there's no ill intent, just mistakes. Often it's a lot of collection of that bad lawyering, a totally underfunded public defender system. These are good folks that are committed, that enter into being a public defender because they care about this, and then they are overwhelmed with a caseload of 100 felonies and no investigator. That is a recipe for wrongful convictions right there. We've got this addiction to the plea agreement, right? And these plea, we're just really squeezing people to plead guilty to things so they can just get out of prison. We've done enough. We've made enough bad choices in the criminal justice system that we've just made a prime environment for wrongful convictions. Some of them are malicious. In my view, Lamar's is one of those.
Right.
But oftentimes it is just the system producing what we have set it up to produce.
And now, while we're on that subject, let's talk about some of the procedural issues in his appeals and the claims that were made and the grounds that he tried to get a new trial and what happened with those. I know that he filed a direct appeal.
Yes.
And I believe that it was about 9 claims of prosecutorial misconduct.
Yes, he was represented in the direct appeal phase, if you can call it that. I mean, he was represented. There was a number of late filings, and things didn't get filed on time, and it was consolidated with his, what we call in Missouri, the 2915 motion, which is a post-conviction motion. And so he had some real lacking representation at that juncture. But there still was a claim of innocence at that time. There was a claim of newly discovered evidence. There were all these letters from Phil Campbell that Phil Campbell had been writing in the jail after Lamar was convicted, but even before he was sentenced, saying, I'm sorry, there's been a mistake. I feel bad about this. Nobody ever hears that evidence in the sense that, Philip Campbell doesn't come in to testify. These letters aren't part of a record. It's just a mess from trial all the way through. But he ends up, losing his appeal, his consolidated appeal. And then by that time, he is pro se all the way up until the recent filings on his behalf that I, along with the Midwest Innocence Project, have filed for him beginning in 2019.
And that included a federal petition for a writ of habeas corpus, correct?
Yeah, he took a federal, he did what, the federal habe, as we call it.
Yeah.
He filed that on his own. He was unrepresented. He was not granted a hearing. He was not granted a hearing in a single one of his pro se filings. So there has been no testing or hearing or fleshing out of his evidence of innocence ever.
So what newly discovered evidence was used for when you came on board and the Innocence Project came on board to be able to file another petition?
So we have not filed what we would consider, a traditional filing in an innocence case, which in Missouri is a Rule 91 habeas corpus petition. That has not been filed by Lamar with us as his counsel. The reason for that is because Kim Gardner was elected in the city of St. Louis and created a conviction integrity unit. And that unit agreed to allow us to come in and make a presentation, which we did in early 2018. They, were like, well, this is interesting. We're interested in hearing more. And if everything you say is true, we're definitely interested, but we're going to verify on our own, which is what they did. for over a year. We interviewed witnesses. They interviewed witnesses on their own. We deposed Greg Elking. There was a lot of record review. And then through their own investigations, they found a number of undisclosed documents. And when I say undisclosed at trial, but also things that we had been requesting, not just previous administrations, but of the Attorney General, of the Police Department, of the Circuit Attorney, been asking over and over and over for these type of documents that evidenced what we knew by that time, because Greg had told us I was paid. They paid my rent. They paid for diapers. They bought formula. They moved us. They paid my back utility bill. They fixed a bunch of tickets for me. He had been saying that to us for years, but it's not the same as getting the ledger that has been kept.
That's what I was going to ask. Did they try to hide these payments, or were they just right there in their accounting ledger that anybody could have found if they would have known to look for it?
Another question that I can't.
Okay.
Answer, but I just don't know the answer.
Right.
But what I do know is when I asked Kim Gardner's conviction integrity unit to look in their files, they found it.
Okay.
So I don't know why it was not found before, but not only was it not found, I was told that not only do we not have it, it does not exist.
Okay. So that sort of answers.
That's a different, thing. It's a different thing to say we don't know, or that it's too old. You're coming to me 25 years later. I have no idea what you're talking about. And then to say I don't have it and it never existed. It's different.
Right. Now, Kim Gardner, and I want to make sure everybody understands this. Kim Gardner is a prosecutor. Okay. And when we're talking about the conviction integrity unit, they came in to investigate. That's what Lindsay was just talking about. And it was Kim Gardner that actually filed the motion for a new trial in July of 2019.
Yes.
Is that what it was? Yes. And then you joined in on that motion, correct?
Correct.
So, okay, I'm going to show something on the screen in a second here, but I'm going to post in my Facebook group to everyone watching. I am actually going to post a copy of the conviction integrity unit report because it's really interesting to see, but I'm going to put it up on screen here, just one part that I think is just really important. So let me pull that up here for people to see. And I don't know if you can read it, but the part that it says, it seems so logical and it seems to make so much sense, and it's how things should be. And it says, it offends our most basic notion of fairness and corrodes public confidence in the justice system for anyone to be imprisoned for a crime they did not commit or because they did not receive a fair trial. Prosecutors cannot ethically ignore credible claims of a wrongful conviction. It seems like that's how it's supposed to be. And it's not that hard. So, it's nice to see any prosecutor actually saying this and believing it, because I know there are a lot that don't. But it's like I said, to me, it just seems like such a simple concept. It's like if you find out somebody's innocent, you should be fighting to get them out of prison. You shouldn't be fighting to protect your conviction rates or, protecting the verdict for some reason, avoiding a civil lawsuit, or all the other reasons why they keep innocent men in prison. And that's one of the questions I have to ask. And I guess I should just say real quickly that one of the things we're going to talk about is that the prosecutor is the one that's saying he should get a new trial. She actually starts out, when she filed her appellant brief, the very first line was Lamar Johnson is innocent. That was like the very first statement in the brief. But she's still saying he should get a new trial. But then what's happening is you're having the state attorney general coming in and saying, no, he shouldn't get one. So that's why I said it's a really bizarre situation, because you have the state fighting against itself. And how does this get rectified? That's where we are now with this case. And I know I'm jumping ahead a little bit, but I want to get started on that because I think it's really important stuff to talk about, because that's what's in front of the Supreme Court right now. So do you want to talk a little bit more about that, or do you want to go through it? Can you read this document? Probably not.
Are you asking me, Tracy?
Yeah.
I definitely can read it, and I'm quite familiar with it. So
okay.
If you have questions, about it, I could certainly answer them. Like the investigation in this case between the CIU and Johnson was not adversarial, which is how conviction integrity units run. And the best practice of them is it's a fact-finding mission. It's not somebody hides the ball and we try to beat each other and win and collect wins and losses. The whole goal is to find the truth and let the facts take you where they go. So this document is a culmination of, joint investigation, their own investigation, but a lot of conversations between the two. And we opened up our entire file to the circuit attorney's office and told them, whatever we have, you are welcome to it. We're not hiding anything here, which is how you must approach really any innocence case. I mean, you've got to be in the business of, here are our cards and this is all. Right. I mean, because, your word is you've got to have it. And so we offered our investigation to them if they wanted it. There was nothing that they ever asked me for that they would have gotten a no about now or anytime. So.
Yeah, I was just leaving this page up so people could see if they want to look real quickly just down that list of some of the things that they found. It's kind of a summary of what they found during this investigation. And again, I'll put the whole document up on in the Facebook group later so you can read it, because my viewers in general really love reading stuff. They love reading documents, transcripts. They always ask for that kind of stuff. So, but also if you want to go to the Midwest Innocence Project's website, which is scrolling on the bottom, themip.org, if you click on, I think it says current cases, and you select Lamar's case, it will show you like all the recent filings. So you can look at the different briefs. Another thing that, being that it's in front of the Supreme Court right now, there are a lot of amici briefs that are being filed. And one of them, again, that just strikes me is that one of the amici briefs is of 45 elected prosecutors, elected prosecutors that are saying he should get a new trial. One of them included is actually the Milwaukee County DA here, Chisholm. But so again, it seems almost unheard of that you can have prosecutors saying, give him a new trial, and he's still not getting a new trial.
It is unheard of. I mean, what is happening in this case is offensive.
And that's why it's going in front of the Supreme Court, right? Because this is obviously, they said it kind of like the state's fighting against itself. So now my understanding is that the Attorney General, Eric Schmidt, his argument is that he's saying that not only does Gardner not have the right to ask for a new trial, but that the court doesn't have the right to grant one. Mm-hmm. Now, I'm just saying, if this is similar to, I don't know if this is similar to Wisconsin or not, but under Wisconsin law, you can file a petition for post-conviction relief based on newly discovered innocence. Yes. You cannot file a motion for a new trial based on in the interest of justice. The circuit court does not have any inherent authority to overturn a conviction based on in the best interest of justice, or because the controversy hasn't been fully tried. The Supreme Court has the judiciary discretion to be able to do that, but the circuit court can't. So is that what he's trying to say, or is it something completely different?
I would say that it's similar to that. We have, rules of procedure like many courts, all courts, and our rule for motions for new trial is 2911. And within that, there are a bunch of time limits and things. But in our argument, in our view, those apply, and understandably and rightly so, to defendants. But in the situation where a prosecutor come as a minister of justice, as an officer of the court, as a quasi, judicial officer with roles and responsibilities to do justice and to tell the truth and to administer justice, when a prosecutor wants to file something, the rules of 2911 are silent as to whether or not she has that right. But if it does, we need to fix that, is our argument. Right. And circuit attorneys, we believe that the law permits this, and currently, as it is written now, she should be able to do this. But if not, Supreme Court, we believe that you should use your inherent authority to correct a manifest injustice when one is presented to you, or your inherent authority to rewrite the rules, correct the rules, make the laws. And we are arguing, as well as the circuit attorney is arguing, that this is a case for that type of the exercise of authority.
So what exactly is the Supreme Court going to rule on? Are they going to rule on the question of whether the court and the prosecutor has the right to do this, or are they going to rule on the merits of the case at all?
You know, how broad or narrow they rule, you know, we'll all see together when it comes across the filing. You know, we all get notice of that. It's possible that they could rule broadly and say, listen, 2911 as written doesn't speak to a prosecutor's duty. It is our opinion and our judgment that a prosecutor has the discretion and the authority and the duty to exercise her authority in this way. They could make a broad opinion like that not only applies to Mr. Johnson, of course, but other cases or other prosecutors should they decide to do this. They could rule narrowly on another issue and only apply to Mr. Johnson. I mean, the Supreme Court has great flexibility in what they decide to do here. Courts generally try to rule, it seems like, at least from my perspective, narrowly most of the time, but who knows? I mean, we'd certainly like to see the right of prosecutors in Missouri and the duty recognized formally by the Missouri Supreme Court. So
what is the next thing that needs to happen in this case that will be happening?
Well,
before it actually, is there anything left before it goes to the Supreme Court for decision?
We're waiting.
Okay.
So
Everything's been filed.
Briefed. Oral argument is completed. So it's the case is submitted at this point. And
is there a place to listen to the oral arguments?
It's on the Missouri Supreme Court's website.
Okay.
You can listen to it. The argument date was
write that down.
April 13th. So you can find it by date.
Okay, perfect.
Uh-huh. So
now it's just a waiting game.
It was the first virtual argument for the Missouri Supreme Court. So it was the first argument that the court did post-COVID.
Oh, wow.
So it was, it's a little difficult to hear right in the beginning, but it does get better. So
how did you feel that went overall?
I didn't think that it went terrible. Like, it was hard for the litigants, I think, to hear at certain points was a little bit stressful, but I thought it went well. I mean, I was glad that we did it. I wouldn't have wanted to submit this case on the briefs. I think it is, oral argument is useful. I hope it's useful to the court, but I wouldn't have wanted to give up oral argument. And we were not in a position of feeling comfortable to wait until courts were back doing in-person arguments with coronavirus and prison being a potentially really awful situation, as we're seeing in many institutions across the country. So it was kind of a balance. We want to do the best thing for Lamar and also keeping in mind that it's a matter of time before Jefferson City Correctional has a COVID outbreak and not wanting to delay this matter any further.
Right. So, Ricky, I'm going to go back to you for a second because I'm going to scroll through, and I know people have been asking questions and they've been scrolling by. So I'm going to go search for those. But why don't you talk a little bit more about how Lamar is doing right now, and also tell everybody about your promise that you made with him, before you left, and what you guys talked about, and about how his frame of mind is now and how he's doing.
Sure. So Lamar and I had made a pact. We, my case had got some early traction, but just as in Lamar's case, the state of Missouri found small things to niggle over for almost 10 years. So in 2009, my case facts were flushed out, clearly flushed out. But it took 10, they niggled for 10 years over jurisdiction, over this, over that. Wait a minute, left before right, and right foot before left, just ridiculous. So it slowed me down, and Lamar's case was picking up traction before he started running into these hurdles. And so we was really about dead even for a matter of years. And we used to look at each other, holding each other up often, and then saying one day when we was on the yard that, listen, man, one of us is going to make it out of here first. We got some good stuff going. These facts are accurate, true, and proven. Whoever makes it out first comes back to get the other. Deal? And we looked at each other and we made a pact and commitment that, again, whoever made it out first would come back and get the other. I, of course, made it out first. And one of the things that is bothering me a lot, and it's hard talking about it, is that I'm here and he's still there. I came home and I thought that I was okay from prison. And it's almost like you get into a bar fight or something and people check your body over to see if you stabbed. And I'm saying, I'm okay. Only to later realize that I'm leaking. I've been stabbed because my first post-release issue has been survivor's guilt. And sometimes I don't know when to celebrate or when not to celebrate. I don't know when to feel good or not to feel good because my friend is still there. And many people, for that matter, is still there. So it's almost hard at times to really kind of enjoy a moment that I should enjoy because my guy's still there.
Yeah, your heart's still heavy because he's still there.
Yeah, my guy's still there. And as it relates to how he's doing, not good. Mm-hmm. I can tell you that, and I'm so close to him. I can tell you that, but I've been through it too, so I can tell you that not good. He's tired. You get tired. He's frustrated. He's irritated with COVID-19. He's likely scared, and quite frankly, I am too. So there's a case in Pennsylvania where a guy died of COVID-19. Who was waiting on his appeal, and it was a strong belief that he was innocent. Last name Rudolph, I forget his first name, but the first thing I thought about is Lamar and really other people as well. How many innocent people might just get affected or might even die waiting on an appeal or fighting to prove their innocence and actually dying in the process of it. So he's not doing good at all. I can't say, I would love to say, oh, he's fine. He's holding up well. He's not. He's definitely not. And sometimes we pretend that we are because we don't want to burden our lawyers or our loved ones. But he's hurting. He's hurting right now much more than I am, but I'm hurting for him as well. So
I think that goes along with one of the first questions. Eric was asked another question, but he said, does the weight of being locked down behind cold steel ever get you near despair? I think the obvious answer is yes. I mean, there has to be times where you get to that point where you feel like there's no hope, or you feel like, and that's why we talked about this last time, that sometimes just getting a letter from somebody saying they support you is enough that can just make your day. It can just brighten everything up for you because, you're sitting there thinking, feeling you're alone, that nobody cares, nobody's thinking about you, whatever, and then all of a sudden you get this letter from maybe even a complete stranger just saying, I heard about your story. I feel for you. I'm here to support you. I want you to know that we're pulling for you. Just that can go a long way towards improving someone's frame of mind. Correct?
Agreed. It definitely was helpful for me. And to receive mail, to receive support, to receive Lindsay Runnels visits, all of that played a key role in me holding it together. I always say that my supporters, some who I knew, some who I came to know, if it wasn't for them being my floating device, at times I feel like I would have drowned. So that's definitely helpful.
Okay, I put Lamar's address up there, right? Emailing address. I said if you don't have the money to donate, if you don't have the time to get involved any other way, if you can just send a letter. And I know we have a lot of people that write letters in this group that watch. So if you time to write a letter and say, hey, like we're thinking about you, or we're pulling for you, I think that would be really great. I think he's really happy to see it, especially if they're new people. So he knows that his case is, new people are coming in and new people are supporting, and and it's not, it's not just the same people that the word is getting out about the injustice that's been done to him. Here's another question. Let's see. So Eric, so has his pro se affected him being? Okay, Lindsay can answer this one. Has his pro se affected him being procedurally barred from any info you need to prove his innocence?
So
does that matter when it comes to the prosecutor?
It's a really good question. So in the filing that Kim Gardner has made, no, because it's a motion for a new trial. It's the first of its kind. And so, no. In Lamar Johnson's Rule 91, of course, if this all doesn't work, right, if we lose at the Missouri Supreme Court, it's most likely that Mr. Johnson will be filing a Rule 91 habeas corpus petition very soon on his behalf. At that point, he will have to overcome procedural bar for a couple of reasons. Time, and these claims have been raised before. He can do that in a couple of different ways, and Lamar Johnson meets the standard on any of the ways we choose. So the actual innocence standard is a way to raise otherwise barred claims. If you can prove and show evidence, clear and convincing evidence of innocence, you're going to pass through the innocence gateway, and you're going to be able to get those other claims heard. He can also prove, cause and prejudice with these Brady claims and the misconduct claims. If there is a cause external to the defense, that, like a Brady claim always is, right? It's hidden evidence, and that you were prejudiced because of it, you can raise procedurally barred claims. So he has the innocence gateway, both the Amrine in Missouri and the Schloop gateway, and the cause and prejudice / manifest injustice gateway. Lamar Johnson meets all of them, but he will definitely have to meet a heightened burden to get into court. I'm confident, his lawyers are confident, he meets the burden.
So actual innocence is actually a grounds that you can use in Missouri, because we don't have that in Wisconsin. We don't have an actual innocence.
Yeah, we have an actual innocence claim. It's called an Amrine claim, named after, of course, the case that the Supreme Court decided at Joe Amrine, an exoneree from Kansas City, Missouri, who is still thankfully with us and part of the movement, and does, always is available if we need him to be speaking to people or talking or doing the right things. But Joe Amrine was a capital case and came very close to execution before he was granted a stay. And then his case was heard, and the Missouri Supreme Court recognized a freestanding claim of actual innocence in that case.
Yeah, I wish we had that here. I don't know how much they would use it, but I wish we had the option.
There's argument here in the last few years that it doesn't apply to non-capital cases. We're arguing about that, and we'll see. The Supreme Court of Missouri has not yet spoken.
Why would that matter? Why does it matter if it's a matter? If you're innocent, you're innocent.
There would be nothing in the case law to suggest that type of distinction is one that the Missouri Supreme Court, the Supreme Court of the United States, or courts anywhere have thought of as a distinction. If it's unconstitutional to execute an innocent person, it's certainly a constitutional claim or a ground for relief to have someone die in custody who is innocent.
Right.
Yeah, and if I could just jump in there, a small caveat to this whole point. In my case, my judge ruled I had a Brady issue and I had a freestanding. This claim that Lindsay is talking about, that was the state would argue it's reserved for death row inmates only with the claim of actual innocence. I was actually granted that standard, a freestanding claim of actual innocence, by Circuit Judge and Honorable and Courageous Darren Atkins. So I actually did receive it, but not so fast. The state did not, it has no binding authority, only enough to get me home. And if the state decided to appeal it and take it to the Missouri Supreme Court for them to decide on, that's a different story. One of the reasons I believe, I'll speak for myself, that the state attorney general did not decide to appeal my case is because that issue was in there. When Judge Darren Atkins gave me that freestanding claim of actual innocence, remind you, Lamar can't use it. Nobody else can use it because it's not binding, because the Missouri state, the Missouri Supreme Court has not ruled on it, have not taken that issue up. And I believe they didn't want them to take the issue up because they could have. And then they could have ruled on it, and the state could have lost. And then it would have been binding. And then other people like Lamar and others would have had a much, much easier chance of using that standard and getting the relief they deserve. That's my novice assessment, I think. I could say that by me not being a lawyer. I don't know about novice, but my non-lawyer assessment. Lindsay can lend a little more credence to that, possibly. Lindsay, is that a correct assessment that I'm breaking down?
Yeah, the Western District of Missouri in the Rodney Lincoln case decided in that case that the Amrine claim was not available to Rodney because he was not a capital inmate. That's a Court of Appeals opinion, but the court, and when I say the court, I mean the Missouri Supreme Court, has granted evidentiary hearings on Amrine claims in non-capital cases since that came down. Now, that's not a binding opinion of the Missouri Supreme Court saying we disagree with that Western District opinion, but in our view, it is a pretty good indication that the court might agree with us in that it, of course, applies to everybody. Now, we don't know. The court hasn't yet ruled, but Lamar Johnson, if he is filing a Rule 91, will be making an actual innocence claim. Nobody is prevented really from raising them. We will argue, certainly, with the Attorney General in the long battle of procedural back and forth that this Attorney General and the one before it and the one before that, Missouri, has done in innocence cases about whether or not Lamar Johnson is even entitled to a hearing on his claims. And so we'll go back and forth about that, but Lamar Johnson will raise an actual innocence claim.
And going back again, this is all with the prosecutor or a prosecutor investigating this saying, again, first sentence, Lamar Johnson is innocent.
This Attorney General and the one before and the one before and the one before until for modern history in Missouri has had a real aversion to innocence cases. Now, so this is not anything specific to Mr. Schmidt. It's a problem. It's offensive to the notion of fairness and justice. But
Right.
Johnson's case is different. It is not just that is overwhelming and that we have hundreds of pages of exhibits and affidavits and deposition testimony and virtually have attacked every single piece of the state's case has fallen away and no credible evidence remains to convict Lamar Johnson. It's not just that. It's that plus the prosecuting authority that charged, convicted him, and sent him to prison for the rest of his life agrees with it. To not have relief in that situation that is immediate is something that is mind-boggling to anybody that has any real appreciation for due process clause or fairness and justice and these buzzwords that we throw around all the time that are really supposed to mean something. Prosecutors in this country enjoy extraordinary power. It is virtually unchecked and discretion, and that is an age-old tradition of our justice system. The discretion of an elected prosecutor is sacred. And we worship at the altar of discretion and power of a prosecutor to do what they believe in their wise discretion they should do. All of a sudden, we're not so keen on that here in Missouri. Everybody can posit about why that is, but this is not the first time that a prosecutor has done the right thing in Missouri. There have been prosecutors that have vacated convictions. They've walked into courtrooms and they've done it, and it's just happened. 2018, 2 gentlemen, convictions were vacated in St. Charles County, the county to the west of where Kim Gardner is. The head of the prosecuting association, Mr. Tim Lamar, walked in and did that in a case. And we should be thankful that he did. But there was no uproar. The Attorney General didn't seem interested that happened. Nobody tried to stop that case. Here we are, and not even a year later, and Kim Gardner is getting a lot of backlash for that. And those are the questions that are before the court. Is that why? And what are we doing? It can't be true that one prosecutor has the authority and another does not.
Right. I honestly don't want to know what the repercussions will be or what kind of dangerous precedent it will set if the Supreme Court says that the prosecutor doesn't have the power to do this. That's going to set the whole concept of conviction integrity units back. I mean, the whole concept of investigating to find the truth and helping those who are innocent. they might as well not even exist then, if that's going to be the case. Where if the prosecutor, well, sure, you can investigate, but you don't have any power to do anything about it once you do.
It would be a blow, certainly. We'll see what the Supreme Court, all of us that do this work have probably a lot. You can't do it unless you have optimism and hope. But, the right side of the law is, in my view, pretty clear. And so you have to have faith that that's what they would decide. Now, Mr. Johnson's case is one that, I'm happy that is before the court on this issue. He's got incredibly strong factual basis for his case. And to suggest that a prosecutor that comes that is presented and discovers evidence like this should have no authority or duty to do anything about it, I believe is, antithetical to our.
Let me get to these questions. I don't want to keep you guys all night. Paul asks, and Paul is from Scotland, so we're reaching international viewers at this point right now. Question for Lindsay, please. Given that some people are being exonerated decades after conviction, how important is it that any evidence be carefully preserved?
Yeah, incredibly important.
Right.
So most of our clients are decades after for a variety of reasons. We don't get the cases, and then they do take a long time. But yeah, the preservation issue is one that we don't normally have any control over at all, but is a critical piece of proving our cases, especially in the Brady. Brady is, did it exist or did it not? And so it has to be preserved in that file. The same with physical evidence. I mean, there's lots of cases that at one time had physical evidence that could have been tested, but it's been destroyed or wasn't preserved properly. And so now we'll never know, whether or not the blood stain on the pants was really our client's or not, even though the jury would have been told that it was. So incredibly important.
I lost my case or my place here. This one is to me, I guess, or just enter. If the circuit court doesn't have the authority to overturn a conviction based on actual innocence, it should not have the right to convict if it cannot adjudicate innocence. Well, I mean, it's two separate issues, obviously, but yeah, I understand what you're saying. I think that what you're trying to get at is what we were talking about, the double standard before, is that
there are limits in court's authority for good reasons. All courts have some limits on their authority. The jurisdiction question is a different one, I think, but the authority for a court to do something is well recognized. I mean, it's understandable to me that there's a time limit, for example, on new trial motions filed by the defendant. We would have this situation that the Attorney General tries to paint in this case of defendants filing them over and over and over and over, way out of time. So, of course, some limits make sense and result in a system that's supposed to work and move. And the finality of a conviction is something that is important when we have the right person, right? Mm-hmm. Justice has been done. If you have a fair trial, you're convicted. That's it, right? But we're not talking about those type of situations in the wrongful conviction world. There is no finality in the conviction that is false or that was obtained through the violation of the Constitution. That's not something that we should adhere to with all of this addiction to finality. Finality is for things that we can be confident are correct. And so these limits on jurisdiction and authority and things like that apply when the Constitution was followed, the trial was fair, and not in the situation where a prosecutor is moving for the reason.
Right. I was just looking up a date on something because I couldn't remember when it was, that some of these issues with inherent authority and discretionary reversals are so confusing in Wisconsin, at least, that it wasn't until, I believe the case was 2011. I was trying to look it up quick, but where a case was actually certified directly to the Supreme Court, because even the Court of Appeals couldn't figure out who had the authority to do what when it came to post-conviction and in the interest of justice cases in general. But that was just in 2011. That was less than 10 years ago. And the Supreme Court finally had to say, here, this is how it works in Wisconsin.
That's what happened. I mean, we were transferred directly to the Missouri, Supreme Court after oral argument in the Eastern District. Mm-hmm. There was briefing and oral argument, but then there was no opinion. It was transferred directly to the Missouri Supreme Court without opinion, which does not happen all that often.
Right.
It's not extraordinarily rare, but it's certainly not something that's common. But for the reasons that the Court of Appeals said in their opinion, you know, undeniably important issues
Right.
In Missouri about what post-conviction relief means, what powers and duties our prosecutors have. So, yeah.
Ricky, I'm going to put this up so you can see it, because Jerome is in Belgium and he speaks French, but he said that, could you please remind Ricky that I would like to invite him to my channel to share his story with the French wrecking crew when I find a translator to help me. Thank you.
Sure thing, no problem.
Yeah, so if you want to get translated into French and reach a really wide audience, there you go. Talk to Jerome. He's a great guy. So
I'm gonna have to go soon.
Okay.
I'm here solo with two littles, and they've been exceedingly good. But I'm on borrowed time, Tracy.
You've given us a good amount of time, and I really appreciate that. So anytime you have to go.
So.
Let me see if I can get through any of these other ones. Is there any precedent? Let's see. Is there any precedent for prosecutorial discretion, or is this a case of first impression under that statute? Travis is a lawyer, so
yeah.
you can speak to each other. You speak lawyer to each other.
Both in our briefing, and I mean Mr. Johnson's briefing, as well as a couple of the amicus briefs. There's an amicus brief filed, as Tracy said, by retired prosecutors and elected current prosecutors. But we also had a brief filed by retired Missouri judges, as well as a brief by post-conviction scholar experts across the country. And in all three of those briefs, our main brief and their amici, they outlined a number of instances that we know of that this has been done in Missouri by prosecutors. Problem is, it's done in the district court, and it's anecdotal because there's not a lot of record of it, right? You walk into the district court, the circuit court, you ask for it, it happens, and nobody appeals it. Who's going to appeal it? The defendant? No. The prosecutor? Of course not. So there's not a long court record of it. So no, to answer your question, it's certainly not the first time. We've gotten some affidavits from retired judges and prosecutors about how it's happened, but it is the first time that it has happened in this way, where someone has tried to do it and the attorney general has entered and tried to stop it. That certainly is unprecedented.
This is just a comment from my good friend Tina, and she's another one that's a really good researcher. Ricky, I'm in awe of your positive outlook and ambition to help Lamar. Keep your chin up. You have a whole wide audience, have a worldwide audience cheering you on. I can't read. Sorry.
Agreed.
Thank you so much. I appreciate that.
Do you guys have any other questions so that Lindsay can get going? I don't see any more. So I will just say this, that it was an honor to have you both on. Ricky, you and I are great friends now, so, so you and I will be talking many times, I'm sure.
Absolutely.
But Lindsay, anytime you ever want to come on and talk about Lamar's case, any other case you're working on, you want to drum up some support, you are welcome to come on. If you ever need some extra eyes, we have some great researchers and great web sleuths that are that are my viewers. But thank you so much for taking the time and coming on with me. And I will let you guys go. And is there anything else you'd like to say before we go?
Thank you for the interest and for lifting up these issues, because they are important, and the more people that know about them, the more people are voting in their DA elections and all of those prosecutorial elections that are so important. And that's all I would say. Know your prosecutor. This is an incredibly powerful position in the place where you live, and they can do incredibly good things, like keep us safe and charge crimes. But they can also do the hard and necessary work of saying, we made a mistake and we're going to correct it.
Well, best of luck to you and good luck. And I mean, I hope that hopefully we can eventually get Lamar on here too. Like, that's the goal.
I hope he's with me, right? I hope it's not so long that I have to come on again and talk about his case, and that he can be here to talk about it himself.
Yeah, that we have to keep thinking positive, and that will happen. He will come on and he will talk about freedom and how much he's loving his freedom. That is the goal.
I have no doubt about it. I promise it.
So we'll let you go, Lindsay, and Ricky. I'll keep you here for a second if you have anything else you want to say. But thanks to Lindsay, and we'll talk to you soon.
Bye.
Bye. I'll be in touch.
Okay. So is there anything last words you want to come up with?
Just the fact that we need to be cognitive, Tracy. We really need, and I really love this platform. I love what you're doing. I love that your audience is there and listening, because we get to reshape this culture of ignoring things. Like we really do get to participate. On my personal platform, I Am Resilience. One of my favorite quotes is "The pen is in your hand," and so we get. What that means is, and I say this as well, we don't often get to decide how our tragedy or our challenge begin, but we do get to decide how it ends, and that's where the pen is in your hand come from. And even in cases like this or circumstances like this, that doesn't just apply to Lamar, but all the Lamars and the Lynnettes across the country who's wrongfully convicted, we get to participate, but people don't often know how. Lindsay alluded to that just a second ago. We can do it at the voters booth. We can hold our elected officials accountable, learn a little bit more about them. When we do go to their meetings and their forums, ask them, how do they feel about wrongful convictions? And really start having a serious discussion about that. We can support our innocence projects across this country, and they're everywhere. I myself will be doing something on May 11th with Gonzaga University Law Club. They have formed the first part of it, which is called a law club, but they're actually trying to become an innocence project. It requires a couple extra things. I flew down there in February on some other business, but was able to meet with them and made a commitment on site to help them create the Innocence Project down in the area of Spokane, Washington. That's important. We have two down here, the Midwest Innocence Project, Miracle of Innocence. We have great attorneys like Sean O'Brien, Cindy Dodge, Lindsay Runnels. I mean, a whole host of lawyers that's not even directly related to Innocence Project fighting these cases, but we need to support them. We need to support them. We need to support platforms like this. We need to support innocence projects. We need to support individual lawyers. We need to support the innocent by sending letters or sending out shouts of love. And even if you can't do nothing, we can, for those who pray, we can pray. There's always something that we can do. And if you're not spiritual, just continue the conversation going. Having the conversation, Tracy, is like leaving the lights on. And the burglar is never going to come in until the lights go off. So we want to purposely have these conversations about Steve Avery, Brendan Dassey, all of these individuals that we're not going anywhere, folks. That's what you let them know. That's what this does. Say, hey, we're not, maybe we'll tire them out. That's what I think they be thinking, that we'll just keep them in prison. Maybe the lawyers will go away. Maybe they'll run out of money. Maybe the supporters will run out of breath. But I just like to say collectively that we're not going anywhere. And I think I certainly speak on behalf of myself and my team here at I Am Resilience, but also I think I speak for many people who have shown up, even people who have shown up and who are listening today. That's an indicator marker that we're not going anywhere. And I'm excited about that.
And Bean Green just said, I love Ricky's enthusiasm and positivity. Yes, we do. Yeah. And, and Tanya just said, everyone can do something, even if it's just hitting the share button. Now, Julie was asking, do you know when the AG is up for re-election there?
I think this November, if I'm not mistaken. In fact, I'm almost sure. And so some of the things that we can do too is engage who we would like to see as our next attorney general or our next elected official. When I was in St. Louis about 3 months ago, on the stoop or champion for Lamar's release, I ran into an attorney general or an individual who was looking to run for attorney general here in Missouri. I think his name was Michael Finnery. But we had a brief conversation about, and he's an ex-prosecutor, about how he feels about this and what would you do differently. And he was there in support of somebody who's running for Missouri Attorney General, was there in support of Lamar Johnson. And so we need people like that who is willing to do their job no matter what it looks like. When it comes to sending a person to prison, when it comes to letting a person out of prison who we sent there wrongly, that is what should matter to us. Those are the type of elected officials that we want in position. I have not followed up on Mike Fennery. I do not know where he's at in his campaign. But though, again, those are the type of individuals that we want to court or have conversations with and make sure that justice is done and justice is done right.
Now, you have some other things that you're working on. I know you said that it's kind of down the pipeline a little bit, but you're hoping to do the videos of your own, and any information can be found on your resilienceMode.com website, correct? About
yes.
What you're doing? Okay.
Yeah, absolutely. For your viewers, you can follow me on all socials, Ricky Kid IAR. We are doing some very exciting things as it relates to two topics. One, broken justice, fixing our broken justice system. But the other one, which came out of my wrongful conviction, is identifying my resilience, my ability to be resilient. People often ask, man, you're sure resilient. How did that come about? And what I've done is I've crisscrossed the country sharing with people my 5 keys to overcoming or activating your own resilience. Tomorrow, in fact, I am going to a resilience training session where I'm teaching resilience from an inspirational point of view. I'm teaching resilience from an experience point of view. But once I came home, I was put in contact with the right people that's going to give me the academic, educational aspect of it, to where I'm making sure that I'm delivering solid information to how we can all become resilient. Listen, why is that important? Even in the space of the legal field, because it takes many years, long, hard fights to get through this stuff. And we have to be resilient, whether that's the client, whether that's the lawyer who fights alongside the client for 14 years, whether that's the family member, and like Dorleen with John's JUCO mother, she is resilient. We have to be. Collectively, we have to be resilient, even as a community, to be able to withstand what it takes to actually correct these type of injustices. So I believe both go hand in hand. Tracy, we're really excited about what we're doing over here and how we look 2, 3, 4, 5 years down the line. Being consistent, we're going to move that proverbial needle, and we're really excited about that.
Okay, and Eric was, you already know this. We talked to Eric was, I did tell him that you sent him a message, so I didn't forget. So he said he would love to speak with you on his channel.
Sure.
Yeah. And so he'll get in touch with you. Coming up here, he said Ricky knows that, if there's anybody else that he knows that wants to get the word out, talk about anything, he can just let me know and I'll get in touch with them. Speaking of Doreen Giuliano, that the John Juca case, she wants to come on again prior to John's hearing on May 28th, and she wants to come on again afterward. So she really wants to come on a couple more times. She really enjoyed it. She's like, I love you guys. Doreen actually has another case that she wants to start drawing attention to. I'm not going to say the name right now. I'll wait for her to talk about it. But this individual, she said, has nobody fighting for him right now. She just helped him get a pro bono attorney, but they really need help. And so with all the web sleuths and the researchers that we have out there, I'm hoping when she comes on, when she talks about it a little more, we can maybe get some people that can really maybe start helping her out, looking at some documents and trying to help this guy, because she's very convinced that this young man is innocent and that he's sitting in prison. And right now he's got nobody. He's got nobody there for him at all. And so I'm looking forward to her coming on to talk about that. Daniel Vegas, who is another exoneree, he actually had 3 trials. First trial was a hung jury, 11-1 in favor of conviction. One juror hung it up. He had a second trial that he was convicted, and then he had a third trial where he was found not guilty. And so he's an exoneree as well. And I've already talked to him. He's really excited about coming on, but he has to talk. His attorneys are being funny right now because he's in the middle of civil litigation. So he has to get the okay from the attorneys, even though I don't think he really cares. He might just come on anyway. But he's trying to do it the correct way so he doesn't upset his attorneys. But he's really excited about coming on. I know I have David Sale and Tanya Henry and Tammy Capps. I've talked to them about coming on to talk about the Wayne Grimes case. And I've sent a message to Christina Brazil talking about having her come on. I would like to get the point of view from family members and friends. just to get their perspective of wrongful conviction, of what it does to the families, what it does to the people that are stuck picking up the pieces on the outside. I think that's a really interesting perspective, because I think that families are sometimes the forgotten victims as well. You know, it's terrible for the person who's inside, but it tears apart families. You know, it ruins a lot of lives, not just the person that's inside. And so I'd really like to be able to talk to more people that are family members and can talk about it from that point of view. So those are some things that I'm working on, and some people that I'm looking to talk to, and I've been in contact with them. We just haven't got anything firm yet, but hopefully I can get to the point where I can have somebody on at least once a week, so we can keep this train going. If more people want to come on more often, I'll do that too. So, and I'm hoping that Ricky and I can work on some of the things that he's talking about in the future. We'd really like to do work together on this some more. So
Excited.
That's it. What?
I said I'm very excited about it.
I am too. I was really happy after our conversation this morning and some of the things we talked about. I'm really excited about it. And Ricky is also selling some gear on his website. He has a t-shirt, and I'll be getting one as soon as I can afford to buy one.
I wasn't going to mention it, but yeah, sure. And really, I should actually.
Yeah, you should.
And thank you for mentioning it. Here's why, Tracy. When we go to speak to legislators or try to get policy changes, that cost. Even when Lamar comes home, something has to be in place for him. And I always say, I tell people all the time, they say, Ricky, you're working hard. And I always tell them, I give Lamar his honors. I say, I'm working twice as hard because I got an exoneree friend that's coming behind me. And I know what it was like when I came home and really having somebody there for me. So I really want to try to be there for him. I don't use the hand out formula. I use the hand up formula, where this is what I'm trying to do. Just reach out, help support us. So we are selling my first inaugural signature t-shirt, I Am Resilience. The pen is in your hand. The shirt is signed. It has my signature on it. Pretty shirt, empowering shirt, in its own sale. If you go to resiliencemode.com, click on our IAR gear, you'll see it there. You'll be able to purchase it. It's $23, folks, for the 23 years.
Why is it 23? Yeah, why is it $23?
Yes, $23 for the 23 years that I spent in prison. And what we want to do over here is be able to take some of those proceeds and put back towards helping other exonerees, supporting lawyers, or doing whatever we can to be able to support this movement. So it helps. Not only does it help me as a recent exoneree who only been home 8 months trying to do something for myself, but I'm trying to put myself in a strategic position to help others when they come home as well. I also have a book called Vivid Expressions, A Journey Inside the Mind of the Innocent. It's a poetry book, a spoken word book. It's already on Amazon.com. So anything like that where people can support, get something for themselves, give back, helping exonerees myself, and then paying it forward, helping other exonerees or individuals. I think it comes full circle, and I probably shouldn't be as shy to speak up about that because that's important.
Nope. Do you have a shirt handy? Do you have one near you?
I'm sorry?
Do you have a shirt handy, the t-shirt handy to show anybody? Do you have one you can show?
I think I do.
If you don't, it's okay. I just figured if you had one nearby.
I go too far. I thought you never asked.
Yeah.
This is the shirt.
There you go.
Resilient. If you can see it, I am resilient with my signature. The pen is in your hand. On the back, it has IAR gear, I Am Resilience, and our website. They're very soft. I wanted this to be people's favorite shirt. A lot of times people sell the cheapest shirt, but we went out of our way with our vendor to get the best quality that is out there, or at least next to, where people can feel like this is an important shirt that when they're feeling down, or because we all are resilient, and everybody's not going through a wrongful conviction, Tracy, but we are going through something. And COVID-19 itself showed us that we all have gone through something. And so really on May 11th, we will be unveiling, and I didn't mean to do it here, but we are talking, we will be unveiling a very special announcement on May 11th on my platforms, Ricky Kid IAR. But we're really trying to do something very special as it relates to COVID-19, but also as it relates to everyday challenges and struggle that everyday people go to. This is an inclusive, not exclusive ordeal, and we really want to try to make an impact. So the shirts, I Am Resilience, again, resilienceMode.com. Click on the IAR icon. That's where you'll find it. The book is out there as well. We're talking about doing a virtual book tour this summer as well. That's exciting. We're doing a mini term this fall with colleges, teaching them about some of the things that you're talking about. The breakdown of the appeal. I love today's conversation. The breakdown of the appeal process, and really going to some of the colleges and universities, talking about the broken justice system from a 3D point of view, having somebody there, not just from a textbook point of view, but from an exoneree himself, showing up for 5 days. It's about 2 hours each day, but we're going to break down the broken justice system aspect and the resilience component, marry them together. We're really excited about that as well. So any support that we can get towards moving in the right direction, towards changing the wrong, making it right, putting justice back on the right track, it's always appreciated and it's always helpful.
Absolutely. And my moderators did put the direct link to the t-shirts in the chat. So we got you covered.
Okay.
Always. So, okay, well, I will let you go, and you and I will be talking soon. And thanks again for coming up here with me. Even the viewers have said how much they really enjoy having you on. You're like one of the family now already. So
thanks, guys. It means a lot to me. It really does mean a lot to me.
And you keep in touch with me about things that are coming up, so I can make sure to let everybody know.
Yeah, absolutely, will do. Guys, take care. God bless. Keep the light on. Keep the light on, which means keep the conversation going. So keep the light on, guys.
All right, then I'll talk to you soon.
Okay, take care.
Bye. So that was it. And I, again, want to thank Ricky and Lindsay for coming on with me. I think it was a great conversation. I hope that more people will read up on Lamar's case, send him letters, show him some support. Obviously, it's a really crazy case because of the fact that, you know, the state, or not the state, but the prosecutor from the state wants to see him, you know, freed, and you know that they're fighting him, and that's why it's so important in the Supreme Court what's going to happen here. It's a really important case, and that's why it's been getting some national attention, because it's really going to be an important ruling, and I will certainly let you guys know when that ruling happens. So let's keep thinking about Lamar, and let's keep going forward with talking about more of these cases and getting the word out. So do you guys have any more questions for me about the, let me remove Ricky's banner. And Ricky is every bit as a great guy as he is when you see him on here. He and I were talking we're going to talk tonight. We talked for an hour and a half this morning. He's just a great guy to talk to, really great. So, so yeah, definitely check out his website, and I will keep you posted on anything else that he's got going on. So does anybody else have any other comments or questions before we go on, or before I let you guys go? It's been kind of a long video, but I can't believe they even gave me that much time. I know Ricky would, but for Lindsay, I mean, she's a very busy attorney. So I'm very grateful that she was able to answer our questions and give us her time. Guys, got anything else for me before we call it a night? All right. So you guys try to share this if you can. That's the big thing, is we want to try to get more awareness. That means sharing these types of things, not just for me, but to get the word out about Lamar's case, about Ricky's case, and about the overall cause for wrongful convictions. That's the part that I'm really pushing for right now. So make sure you share, hit subscribe if you haven't subscribed already, hit the like button to get more attention, and I will talk to you guys next time. Bye.